Honorable Minister of Road Transport and Highways, Shri Nitin Gadkari, Honorable Mr. Justice L. Nageswara Rao, Judge, Supreme Court of India, Professor John Uff, Queen's Counsel and Arbitrator, Keating Chambers, London, Mr. Ratan Singh, Senior Advocate and Founder and Chairman of SCL India and Director of Chartered Institute of Arbitrators, India Branch, Mr. Tejas Karia, Partner and Head of Arbitration Practice Group, Shardul Amarchand Mangaldas, and all the other dignitaries and delegates from all across the globe attending this inaugural of the SCL India International Virtual Conference 2021. Warm greetings to all of you. I'm Raghav Mudgal, advocate at Chambers of Senior Advocate Ratan Singh and a member of Board of Reporters of the Society of Construction Law India. I would like to invite you all to the third edition of this biennial conference on construction law and arbitration. Over the course of the next 3 days, this conference will feature significant developments in construction law and construction arbitration, with a special focus on the future. Our delegates will have the opportunity to participate in a number of interactive events like plenary discussions, workshops, debate, fireside chat, and so on. I'm quite excited to announce that we have 1,211 delegate registrations from 37 countries and 84 speakers from 14 countries who will be contributing to this forum and shaping the future of construction law and arbitration. We have an exciting inaugural event today, which begins with a welcome address by the founder and chairman of Society of Construction Law India, Mr. Ratan Singh. Mr. Singh is a designated senior advocate and an arbitrator based in Delhi. With about 25 years of experience, Mr. Singh is a leading construction law professional and has heavyweight counsel practice, along with assignments as arbitrator in India and internationally for high-value construction, engineering, infrastructure, and general commercial disputes. Mr. Singh has been involved with the industry players and stakeholders through his leadership and chairmanship of the SCL India and directorship of the Chartered Institute of Arbitrators, India Branch. Mr. Singh holds 5 international fellowships, including of CIAB UK. Mr. Singh is the only fellow from India of the International Academy of Construction Lawyers, IACL, which is an elite group of construction lawyers from all over the world. Mr. Singh, I request you to kindly address the gathering.
Thank you, Raghav. Thank you for kind introduction. Good evening, good morning, good afternoon, ladies and gentlemen. Our chief guest, Mr. Nitin Gadkari, Honorable Minister for Road Transport and Highways, my Lord Justice L. Nageswara Rao, Judge of the Supreme Court of India, my Lord Justice A.K. Sikri, former Judge of Supreme Court of India and Judge of Singapore International Commercial Court and Arbitrator, Honorable Justice Sir Rupert Jackson, former Judge of Court of Appeals, UK, Honorable Justice Peter Weekly, former Judge of Supreme Court of Victoria, who established and managed the Technology and Engineering and Construction List in Victoria, Professor John Uff, Professor Mr. Gary B. Bourne, Professor Doug Jones, Mr. Philip Bruna, Mr. Julian Bailey, QCs, Paul Darling, and delegates, the speakers, ladies and gentlemen. Let me begin my address by inviting you to think about a recent project of interest that you would have worked on. Consider specifically the numerous proverbial bricks that have had to come together, interlock, and finally form a cohesive whole. Similarly, and perhaps most importantly, think of the diverse human actors that have had to function just like these bricks, that is, owners, contractors, subcontractors, subcontractors, suppliers, vendors, architects, engineers, government officials, financiers working together to realize a project. And when things don't go as well as one might have liked them to, it is the lawyers, arbitrators, mediators, judges, and experts that must work together to ensure an effective resolution to problems. It is this human element that we are here to celebrate at the SCL India International Virtual Conference on Construction Law and Arbitration. Indeed, we have with us at this year's edition over 1,211 delegates from a whopping 37 different jurisdictions and 80 speakers from 14 countries, as Raghav just said. With this metaphor in mind, it is my privilege as a chairman of Society of Construction Law and founder of Society of Construction Law in India to welcome all the dignitaries, as I said earlier, Honorable Minister for Road and Transport, Mr. Nitin Gadkari, my Lord Justice L. Nageswara Rao, Judge of the Supreme Court of India, and Professor John Off for this inaugural session. We had Dr. Lalit Bhasin, who was supposed to give their special address for today's inaugural session, but I got a call from him half an hour back. He's not well, so he has asked me to not wait for him and to go ahead with the proceeding. A few words about SCL and SCL India. Society of Construction Law was formed and established for the first time in UK in 1984 by the group of lawyers, engineers, architects, quantity surveyors, employers, and contractors. And gradually, Society of Construction Law has its sister branches almost in all developing nations and having across all jurisdictions. Society of Construction Law is set up with an objective to promote construction law as well as best practices for construction industry. It was one of my visits in 2012 to UK when I had gone for some arbitration. I met Mr. John Tuckerberry, Queen's Counsel, who was one of the founders of Society of Construction Law UK. He inspired me to start Society of Construction Law in India, knowing that this is my area of passion, area of interest. And this is how I started with colleagues like Mr. Tejas, Karia, and others, Society of Construction Law in India. And thereafter, we have had multiple events. And whole objective of Society of Construction Law is to promote construction law and best practices in India as well. We are making all efforts to create a bigger and better pool of specialized construction professionals, construction lawyers, construction arbitrators. And in this endeavor, we are also organizing biannual events. And this is our third edition. We started this in 2017, then we had in 2019, and then this is 2021. 2017 edition, we had speakers from 32 countries and more than 350 delegates from all across the globe. And we had the physical conference, 3 days conference. Same was the case with 2019. And in 2019 as well, we had the honor to have Minister of Road Transport, Shri Nitin Gadkari ji, and we had 11 sitting judges, and then we had lots of other dignitaries from all across the globe. This is another important thing which I must start by sharing with you, that over the past 2 years, the COVID-19 pandemic has rampaged the construction industry as it did other areas of life, as we know. Nevertheless, I think all of us would generally agree that industry has shown resilience and has rallied forth through the pandemic's worst effects. At the same time, it is the need of the hour and our duty as proponents of the system to revisit the practices we adopt, the laws we apply, and the policy decisions we take in our work. It is only an honest assessment of these matters that will truly help us to rebuild the industry from any damages the pandemic has caused, overcome any future challenges that might arise, and push the industry to even greater heights in the years to come. Accordingly, this year's conference seeks to foster debate and discussions on the theme, the way forward. The program on offer for this edition features an impressive lineup of sessions presented by speakers, panelists from all across the globe and from diverse backgrounds. Indeed, we kick off this evening with addresses by our esteemed chief guest, Shri Nitin Gadkari ji, Honorable Minister for Worth, one of India's largest employers, our esteemed Honorable Guest of Honor, the Honorable Justice L. Nageswara, Justice of the Supreme Court of India. In fact, this reminds me of the very eloquently, and I would say very beautifully written, a reprimand or reminder to all in all courts in India, when my Lord Justice Nageswara Rao authored his very recent judgment in DMRC case, DMRC matter, that was Delhi Airport Metro Express Private Limited and versus Delhi Metro Rail Corporation Limited. I just quote my Lord Justice Rao when my Lord Justice Rao in paragraph 24 said, there is a disturbing tendency of court setting aside arbitral awards after dissecting and reassessing factual aspects of the cases to come to a conclusion that the award needs intervention, and thereafter dubbing the award to be vitiated by either perversity or patent illegality, apart from other grounds available for annulment of the award. And that shows how my Lord Justice Rao strongly believes in sanctity of the arbitration process and sanctity of the arbitral awards. And obviously, we will have keynote speech for this year's edition presented by Professor John Huff, the Queen's Counsel, member of Keating Chambers, London, which is one. Now I welcome Honorable Minister, Sri Nitin Gadkari ji, Honorable Minister for North. Thank you very much, sir, for joining us. The opening night session, after this inaugural, we will have opening night session on construction, arbitration, diverse perspective, unified goals. Over the next 2 days, the conference will showcase panels on themes of contemporary relevance, such as liquidated damages, EOT claims, risk allocation, COVID's impact on the industry, construction mediation, dealing expert evidence, cross-examination, providing delay claims, so on and so forth. In addition to this edition of the conference features for the first time technical roundtable workshop on advanced topics, as well as special speeches, events such as the construction law debate, quiz, careers panel, and last but not the least, a fireside chat with the living legend of construction law, Sir Rupert Jackson. Sir Rupert Jackson, who demitted office as the Judge of Court of Appeals UK, was also holding the Court of Technology and Construction Court UK, and he is one of the towering personality in the field of construction law. Once again, I welcome everyone here to participate in the events to come. And before I conclude my inaugural talk, I must thank once again Mr. Nitin Gadkari ji for his continued support, even for the last edition of this Society of Construction Law International Conference. When I met Mr. Nitin Gadkari ji, he was kind enough to consent to be part of that event. And this time again, he has been kind enough to be part of this event. In fact, he told me that he'll be very happy to see the recommendations coming out of this conference, and he'll try his level best to work towards all the suggestions which may come out of this conference. And I sincerely hope with this that this conference inspires ideas, discussions, and collaborations that illuminate the way forward for construction law and arbitration in India and globally. Thank you. Thank you very much.
Thank you, Mr. Singh, for addressing the gathering of our dignitaries and delegates. It is my privilege to invite the guest of honor, Honorable Mr. Justice L. Nageswara Rao. Justice Rao is a sitting judge at the Supreme Court of India and was elevated in 2016. He was designated as a senior advocate by the Andhra Pradesh High Court in the year 2000. He then served as the Additional Solicitor General of India twice, from 2003 till 2004, and then again from 2013 till 2016. I request Honorable Mr. Justice Rao to please kindly address the delegates.
Shri Nitin Gadkari, Honorable Minister of Road Transport and Highways, Professor John Off, Mr. Ratan Singh, Mr. Tejas Karia, lawyers, distinguished arbitrators, experts, and all other delegates and attendees, namaskar. At the outset, I would like to congratulate the Society of Construction Law India for this momentous third biennial flagship event of SCL International Virtual Conference on Construction Law and Arbitration, the way forward. SCL's efforts in promoting research and dedication in the field of construction law and collaborating between experts, lawyers, professors, arbitrators, engineers, and all other stakeholders of the construction industry are truly commendable and highly significant in enhancement of expertise in the construction industry, which is rapidly diversifying in light of considerable increase in real estate and infrastructure development. Construction sector in India accounts for about 9% of its GDP, being the second largest industry after agriculture. Along with being the second largest employer, construction sector has been a major recipient of the foreign direct investment and is predicted to make India the third largest construction market globally by 2025. The impact of this sector is not just confined to an industry, but spans across several subsectors of the economy, particularly infrastructure development, such as industrial and mining infrastructure, power systems, irrigation and agriculture systems, telecommunication systems, hospitals, schools, townships, urban infrastructure, including water supply, sewerage and drainage, and rural infrastructure. It is for this reason that the development of physical infrastructure in India, and consequently the construction sector, has been in focus during the last decade, making India Asia's biggest infrastructure investment opportunity. The expansion of construction sector into various other facets of the economy necessitates the application of an assortment of laws ranging from civil laws such as contract laws, property laws, labor laws, model building laws, health and safety laws, to fiscal laws such as foreign exchange management laws, foreign direct investment policy, various RBI regulations on funding, guarantees, securities, etc. At times, it can also attract the invocation of bilateral investment treaties between nations. In addition to these diverse laws, a construction project also involves multitude of parties such as the employer, contractor, subcontractor, project management consultant, suppliers, among others. Substantive disputes arise during the performance of construction contracts. As we have noticed, most frequent disputes stem from the delays in execution or completion of contracts and its associated issues such as allocation of liability, added costs and expenses, untimely termination of contracts, invocation of guarantees, withholding of retention amounts, so on and so forth. Since time is of essence in most of the construction contracts, adjudication of disputes revolves around the attribution of liability for delays to the parties and its allocation to various stages of a construction contract. Ascertaining liability in cases of delay involves an in-depth analysis of various events that occur during the life cycle of a contract, coupled with a calculative approach to compute the extent delays. Many a times, the corollary of anticipated delays in the completion of the contract is the application for extension of time, which invites critical cost analysis. Adjudication of the issue of extension of time and its financial impact on the concerned parties requires a detailed assessment of the effect on the fate of the entire project, the nature and gravity of the event causing delay, and the factors contributing to such delay. Even issues arising out of the variations in the implementation of construction contract involve a meticulous scrutiny of whether the work in question is beyond the express and implied obligations of the contractor, agreement with respect to the payment of such work, the necessity for performance of such work in view of the fault in implementation, and the adherence to the procedure involved in the approval of such variation and extra works. On the whole, adjudication of a construction contract could be quite complex and is required to be conducted with due care and precision. The consequences of a construction dispute have far-reaching impact on the fate of the project. The stakes are quite high, not only for the parties, but for the development of the country as a whole, as the project could be associated with public utility services or could be a product of hefty investments. Keeping in mind the tremendous developments which have taken place during the past 50 years and the present scenario involving contract-based infrastructure developments, public-private partnerships, and other public projects involving huge investments, an expert committee was constituted to examine the Specific Relief Act of 1963. Based on the recommendations of this expert committee, the Specific Relief Act was amended in 2018 to bar the courts from granting injunctions in infrastructure projects relating to transport, energy, water, and sanitization, etc. Looking to the intricacies involved in implementing a construction contract, it is imperative that only fair that the task of resolving the issues and disputes arising therefrom is carried out by subject matter experts using their specialized expertise. This is where the remedy of arbitration is useful and has also proved to be effective. The settlement of disputes through arbitration gives the parties involved a discretion to seek formal assistance from experts and professionals in the field. The decision of these experts instill more confidence in the stakeholders with respect to their case having been thoroughly weighed and pondered over by seasoned professionals with advantage of sector-specific knowledge cultivated through prolific practices in the industry. Time being essence of a construction contract is a principle which is not just confined to the implementation of the contract, but also extends to the effective resolution of disputes. Resolving disputes by reference to skilled arbitrators in accordance with the timelines agreed between the parties during the case management conferences would take care of this aspect as well, as the parties are also free to choose the procedure and stages involved in the arbitration. It also cannot be denied that getting a dispute resolved in a reasonable and timely manner will offset any short-term increase in costs. Costs of arbitrations tend to be lower than that of litigation due to flexible rules of evidence and streamlined procedures. While this appears to be the object behind the endeavor to promote arbitration as a mechanism for settlement of disputes emanating from a construction contract, the situation on the ground appears to be different. As per the press release by the Cabinet Committee on Economic Affairs in 2016, which approved certain reformative measures to aid the arbitral process in construction matters, it was observed that the key factor behind the difficulties faced by the sector is huge pendency of claims. According to a survey, the average settlement time for claims arising out of a construction contract is estimated as more than 7 years. This is so because most of the arbitral awards are challenged in courts, and time taken for disposal of cases by courts naturally contributes to further delay. Judicial interventions in arbitral proceedings, adding significantly to delays in arbitration process, and ultimately negating the benefits of arbitration was discussed by the Law Commission of India in its 246th report relating to amendments to the Arbitration and Conciliation Act 1996. While taking note of the issue, the report attributed two reasons to such delays. First, that the judicial system is overburdened with work and not sufficiently efficient to dispose commercial cases with the speed that is required. And second, that the bar of judicial intervention has been consistently set at a low threshold by the Indian judiciary, which has translated into many admission of cases. The Arbitration and Conciliation Act 1996 was enacted with the key objectives of minimizing the supervisory role of courts, providing speedy, amicable, swift, and cost-efficient settlement of disputes, facilitating enforcement of final arbitral awards in the same manner as decree of courts, and ensuring that arbitration proceedings are just, fair, and effective. Lawmakers were conscious that economic reforms may not be effective unless the law dealing with settlement of both domestic and international commercial disputes are in tune with such reforms. Section 5 of the 1996 Act mandates that no judicial authority shall intervene in matters except where so provided in the Act. Chapter 7 of Part 1 of the Act provides recourse against arbitral awards. Amendments made to Section 34, which delineates the jurisdiction of the court while exercising its power to set aside awards, would indicate the legislative intent of keeping judicial interference with arbitral awards to the minimum. The principles and provisions with respect to limited grounds of interference with an arbitral award are well in place. The difficulty that arises is in the application of these well-settled principles while scrutinizing an arbitral award in its peculiar facts and circumstances. The principle of patent illegality has been grossly misunderstood by courts, which tend to sit in appeal against arbitral awards in the guise of curing the defects in those awards. This practice is highly unwarranted. While dealing with an appeal arising from an arbitral award, especially in complicated matters such as construction disputes, which have already been looked into by expert arbitrators, the courts have to be conscious of the fact that the permissible grounds for interference under patent illegality is when the view of the arbitrator is not even a possible view, or when a clause in the arbitration contract is interpreted in such a manner which no fair-minded or reasonable person would have, wandering outside the terms of reference, ignoring vital evidence, and considering documents not supplied to other parties could be other facets of perversity falling within the expression patent illegality. But the power under no circumstances extends to re-examination of facts and reinterpretation of the clauses of the contract. The other ground which is frequently misconstrued by courts is that of public policy of India, especially in terms of enforcement of foreign arbitral awards. It has been observed that in the garb of public policy of India, courts have a tendency to set aside an arbitral award as being against the fundamental law of India for non-adherence to laws which might not be linked to public policy or public interest. The three grounds encapsulated within the ground of public policy of India, as provided in the explanation to Section 34 and Section 48 of the Arbitration Act, have to be understood with high precision as to its connotation for reviewing arbitral awards. It has been made clear that an award would be in conflict with the public policy of India when it is induced or affected by fraud or corruption, or is in violation of Section 75 or Section 81 of the Arbitration Act, if it is in contravention with the fundamental policy of Indian law, or if it is in conflict with the most basic notion of morality or justice. The expression fundamental policy of Indian law refers to the principles and the legislative policy on which Indian statutes and law are founded. It connotes the basic and substratal rationale, values, and principles which form the bedrock of laws in our country. Further, if an arbitral award shocks the conscience of the court, it can be set aside as being in conflict with the most basic notions of justice. The Supreme Court has interpreted the grounds of morality to encompass awards seeking to validate agreements, which are not illegal, but would not be enforced given the prevailing modes of the day. These principles are well settled and are ingrained in the statute as well as numerous judicial pronouncements, undoubtedly. However, the practice of questioning a well-reasoned and thoroughly weighed award on niche areas such as construction law needs to be discouraged. It needs effort on the part of all stakeholders to make arbitration an effective alternate dispute resolution process. To start with, parties to the dispute should make reasonable claims without inflating them. There is a tendency in this country to make exorbitant claims with a view that you ask for more to get something less. Parties should realize that pending disputes are detrimental to their interests. Endeavor has to be made to settle them at the earliest. MEDAR, ARB-MEDAR are mechanisms which can be resorted to. Mediations can be attempted either to resolve the dispute fully or to settle some of the issues, reducing the number of issues to be arbitrated upon. During the course of arbitration, proceedings can be stayed and mediation can be attempted. If the parties reach a settlement, then arbitration can be resumed and an award can be passed. Counsel should advise the parties to the dispute suitably and assist them in reaching a settlement if possible, and in ensuring that there is early resolution of the disputes through arbitration. In case of appeals filed against awards, grounds should be limited to those permissible under the Act. Lawyers should desist from complicating issues in appeals, which delay hearing of applications under Section 34, appeals under Section 37, and petitions under Article 136 of the Constitution of India. Finally, judges dealing with petitions and appeals for setting aside arbitral awards should be conscious about the limited grounds for interference. There is absolutely no ambiguity in the provisions of the Act. Unless courts in India realize their limitations, arbitration being an effective and efficient alternate dispute resolution mechanism would be a mirage. Only a concerted effort by all stakeholders would make arbitration a successful dispute resolution process, bringing solace to those who resort to it with a fond hope of settling their matters early. With these thoughts on the theme of this year's SCL International Virtual Conference, I once again congratulate the extremely dedicated organizing committee for putting together this elaborate event with plenary sessions, workshops, debates, quiz, fireside chats, and career talks. I look forward to the insightful discussions between the esteemed panelists of the plenary sessions and convey my best wishes to the participants and delegates for their engagement in enriching workshops and other events being offered in the span of coming 3 days. Thank you very much.
Thank you, Honorable Mr. Justice Rao, for your words of wisdom and encouragement. We now would like to invite our chief guest of this international conference, Shri Nitin Gadkari, the Honorable Minister for Road Transport and Highways. Before we ask him to address the gathering, may we please present to you a short introductory video.
There are followers, there are leaders, and then there are visionary. Taking people and society to where they ought to be rather than where they want to be is what separates a visionary from a mere leader. This rare quality is what sets apart Nitin Gadkari, Minister of Road Transport and Highways, from many of his ilk. Born in 1957 into a free-thinking agricultural family, Nitin Gadkari at heart has always been a social worker inspired by the RSS founder KB Hedgewar's ideals of humanity and nation building. Taking off as a Minister of the Public Works Department in 1995, Nitin Gadkari made groundbreaking changes in the speed the city of Mumbai travel. So impressed was the then PM Atal Bihari Vajpayee ji with Gadkari ji's performance as PWD minister that he offered him a responsibility of weaving road nets in the whole of rural India. The outstanding Swarnim Chaturbhuj Yojana, of which Shri Gadkari ji was the chairman, is the culmination of these efforts. 55 flyovers dotting the city have made commuting in Mumbai much easier than ever before. The foundation for the magnificent Bandra-Worli Sea Link was also readied during this time. The jewel in the crown of Maharashtra, India's first expressway, the world-class Pune-Mumbai Expressway, is also a futuristic project imagined and brought to fruition by Nitin Gadkari. Connecting over 13,000 unconnected villages with an all-weather $100 million USD project is another feat accomplished by this far-sighted visionary. Nagpur, his hometown, has seen first of its kind double-decker bridge. An innovative beautification of flyover using local artists and painting of great political and social leaders was added attraction. Ajni Intermodal Station will have connectivity between long-distance buses, city buses, railways, metro and indirect link with city airport. Nagpur Broad-Gauge Metro, which is a commuter rail project planned for Nagpur city and extending up to adjacent areas of Wardha, Narkhed, Ramtek, Bhandara and Chhindwara. World-class institutions like IIT, IIM and AIIMS emerge and thrive under his watchful gaze. This is in addition to the over 1,000 Ekal Vidyalayas that go a long way into molding the future tribal generations. Performing over 10,000 successful heart surgeries is another stupendous achievement in his illustrious career as a warm-hearted do-gooder. The city of Nagpur is the first city to explore alternative biofuels for transport. These include bio-CNG buses. His innovative idea of India's first of its kind CNG-run tractor has proved to be farmer-friendly, cost-effective and helping in reducing air pollution. In a historic push for biofuels, Gadkari ji is introducing flex engines which will run on 100% ethanol, directly providing additional income to farmers and the agricultural sector. Sanskritik Mahotsav, motivating local artists to go nationally. Krida Mahotsav, supporting local sportsmen to showcase their abilities and motivate them to go nationally and on Olympic level. Projects like AgroVision are helping farmers with latest technologies and practices. His idea of using sewage water for power generation, use of ethanol as fuel have added a whole new dimension to the city's development program. As India's current Minister of Road Transport Highways, he has re-energized the whole sector with his clear vision. With more than 40,000 kilometers of national highways constructed in the last 7 years, 60,000 kilometers of new roads under his supervision are being constructed. The speed of road construction from a mere 3 kilometers in 2014 has grown to 40 kilometers in 2021. The dazzling Delhi-Mumbai Expressway has set 4 new world records with 12,500 cubic meters of concrete being laid down on the 4-lane stretch of 25.4 kilometers. These world records are as follows: highway construction rate at 37 kilometers per hour, construction of 2.5 kilometer long 4-lane concrete road near Vadodara at Delhi-Mumbai Expressway in 24 hours, laying down of 26 kilometer long bitumen road at Solapur-Bijapur section of NH52 in 21 hours. A 50% growth in the length of the national highways in the last 7 years of the NDA government is a monumental achievement. The figures went up from 91,287 kilometers to 1,37,625 kilometers. Going further, INR 3.32 lakh crore is allotted for 22 greenfield expressways, initiated by the bridge building messiah as he is fondly referred to. Bharatmala and Sagarmala, 2 world-class access-controlled expressway projects led by Nitin Gadkari, are presently in various stages of construction. The Bharatmala project seeks to eliminate the perennial road traffic movement imbroglio across the country. With Nitin Gadkari taking charge, India's much maligned logistics sector has also metamorphosed from a point-to-point model to a hub-and-spoke model. This multimodal transport system integrates railways, highways, inland waterways and airports, conjuring a highly effective transportation grid, substantially reducing logistic costs and pollution. 35 multimodal logistic parks, 50 economic corridors, 10 intermodal stations are being readied for the monumental effort. Logistics summits with the international participants, including government organizations and the World Bank, leading to MOUs worth 2 lakh crore, have been held to add muscle to the initiative. Among his other endeavors, unprecedented progress is evident in port industrialization, national water highway traffic, jetties for coastal tourism, Ganga Yamuna cleaning, fundraising, asset monetization project, toll operate transfer. As MSME Minister, he has gone all the way to promote entrepreneurship, helping rural youth to adopt Khadi as a means of self-employment. The MSME Ministry has also found wings under Mr. Gadkari. He changed the definition for classification of MSME. Now, a company investing 1 crore and earning a turnover of 5 crore will be classified as micro company. The portal Udyam Registration (UR) offers faceless, fully online, paperless and transparent MSME registration process fully integrated with income tax and GSTN systems. His brainchild, Jal Kranti, Buldhana pattern of water conservation which changed economy of villages by rejuvenating water bodies, has won a global award. Mr. Gadkari introduced the first ever vehicle scrapping policy, which proved to be the fight against pollution and in the interest of road and vehicle safety. New FASTag policy is helping commuters to save their fuel and time on toll plazas. Some of his major work, like unprecedented push for research and development in electric vehicles, leading research and development for usage of waste materials in highway construction to cut down highway construction costs and generate wealth out of waste materials, developing ropeways and funicular railways in the remotest parts of the country, thus boosting tourism. Panchgaon project for women of making carpets from scrap cloth is a classic example of women empowerment. Khadi Prakritik paint, which is made from cow dung, is aiding in employment in rural areas and have exponentially improved rural economy. When all industries were shut in the pandemic, Mr. Gadkari empathized with people by conducting webinars and 800+ video conferences. His quick decision-making in procuring oxygen (PPE) kits helped those affected by the deadly virus. He generously donated ambulances to NGOs, helped to set up oxygen plants, factory to make remdesivir injections and injections for mucormycosis. Thus, by showcasing strong leadership and taking quick decisions, he handled the COVID situation effectively. His affable nature goes beyond everyday personal equations as he continues to transmit his radiance and ideas to every individual or organization with his unmatched zeal. Gifted with an ability to dream the seemingly impossible dreams and getting them to fruition also defines this clairvoyant visionary. Nitin Gadkari shines on as one of modern India's pioneering leaders and his work a template for the coming generations. If there ever was the infrastructure man of India, he would answer to the name Nitin Jairam Gadkari.
Honorable Judge of Supreme Court of India, Respectable Justice L. Nageswara ji, Retired Justice, Supreme Court of India, Shri Arjun Kumar Sikri ji, Director, Chartered Institute of Arbitrators, Dr. Lalit Bhasin ji, the Chairman of SCL, Advocate Shri Ratan Singh ji. Actually, it gives me immense pleasure to deliver a special address to the international conference organized by the Society of Construction Law of India on the important theme that construction law and arbitration, the way forward. I have been told that around 1,200 delegates are registered from 37 countries for the international virtual conference. I had occasion to speak in the previous edition of this conference, and I'm glad to back for this edition once again. Construction contracts are long-term contracts with the involvement of multiple stakeholders and therefore disputes amongst the stakeholders are a possibility, and therefore robust ecosystem for construction law, construction arbitration, and other forms of dispute resolution methods is need of the hour. Actually, from last 7 years, I'm in charge for road infrastructure, and the Prime Minister has appointed a committee under my chairmanship, where Railway Ministry, the Ministry of Mines, Ministry of Environment, all ministers are there, part of our committee. And we are always trying to resolve the issue related with getting permission for infrastructure projects in the country. Presently, the infrastructure development is very, very important for the country. But at the same time, the way in which we are facing the problems, these are the very crucial issues which are facing the prospects of our country. Construction is one of the major sectors of India. It is the second largest industry after agriculture, giving maximum employment, and at the same time making up 9% of India's GDP is coming from the construction industry. The robust construction law and arbitration ecosystem is need of the hour, as a sustainable portion, as a substantial portion of the GDP is invested by the government in infrastructure. The government has given a massive push to the economy by allocating about rupees 111 lakh crore through the National Infrastructure Pipeline Program up till 2025. Recently announced the PM Gati Shakti National Master Plan of more than rupees 100 lakh crores is focused on holistic and integrated infrastructure development in the country. Awareness about the international best practices of construction law among the relevant stakeholders will not only avoid construction-related dispute, but will ensure proper contractual enforcement. Ministry of Road Transport and Highway has been continuously working on various methods of dispute avoidance and dispute resolution, and has been engaging all the relevant stakeholders in such process. The most important thing, which I'm not the expert for the judiciary, but in my practical experience, we are facing problem, first of all, in the system. To getting clearances for, particularly for land acquisition, forest and environment clearances, getting permission from the concerning department, getting permission from the railway and other people and power ministry. Everywhere there is too much delay. And that is one of the reasons that the project escalation cost is increased. Already it is increased too much. One of the important problem which I am facing practically, that as far as the financial institutions are concerned, not taking decision is also a big problem. For getting bank guarantee, 2% of the performance guarantee for the project from bank institution, also it takes 1 year, 1.5 years for financial closure. And that is one of the reasons that we are facing very, very serious problem. When I was taken charge as a minister, there was 406 projects costing 3,85,000 crores cost involved, and the project was delayed and the project was toll project. That was a big challenge. But at that time, we decided to resolve the issues. I called the concerning people, banking people, the government, state government officials, contractors, consultants, and our officers sit together like a big panchayat, and we resolve the issue. And my ministry at that time, we saved 3 lakh crores of NPA, particularly for Indian banks, and we saved this NPA. The 40,000 crores of the cost of the project we terminated. But majoritarily, in my experience, I am very sorry that I am telling you frankly that I don't want to make any type of allegation against anybody. But the maximum projects are delayed. It is because of the system. In the government system, the not taking decision and making delays for the decision was the big problem. Many times I make these comments that the people who are getting the salary every month, they never understand what is the cost for the time. And before INA, after there are a lot of cases are going to High Court and Supreme Court, that is the different thing. Even before that, in the system, there are a lot of problems. I'm giving you the example how much saving if we can make the system transparent, time-bound, result-oriented, corruption-free. I'm giving you a great experience of my life when I was minister in Maharashtra, in Mumbai, as a PWD minister. I was responsible to make Mumbai-Pune Express Highway and 55 flyovers, and at the same time, this Worli-Bandra Sea Link project. I'm giving you the example how the society is facing the problems and paying the cost for the delay and not taking decision for the project. The estimated cost for the flyover project was 1800 crore. I'm talking about 95, 96, 97. And we have decided that the contractor who will complete a project one day before, he will get 1 lakh rupees as a bonus. And if it is delayed, we will fine him 1,50,000 rupees per day. And that is because of this policy, the 1800 crore cost of the flyover project, it comes to 900 crore and we save 50% at least cost on that. The Mumbai-Pune Express Highway, the tender was lowest from Reliance at that time. I remember Dhirubhai Ambani was the chairman of the Reliance company, and we decided to, the project cost was very high because he was quoted 3,600 crore in 96, 97. And my estimate was 1,800 crore. So when we negotiated, ultimately we reject the project. Dhirubhai was very much annoyed because he was the lowest. And already at that time, this Mumbai-Pune Express Highway, we have completed with the cost of 1,500 crore and saved 2,000 crore on this project. It is because of the time clause, getting incentives for the work on time. And I'm giving you the example of Worli-Bandra Sea Link project. The cost of the project when we awarded to SSC, Hindustan Construction Company, the cost of project was 420 crore. But because of the environment activist, and after there was a matter was sub judice, the project was delayed and ultimately that cost come to 1,800 crores. So these are the costs where it involves because of delay. So one of the reasons which I will request to all of you, because you are the respectable authority in the government and out of the government, the first of all, we need a mechanism by which we can take the decision at the appropriate time. And the time is the most important constraint where we can resolve the issues and we can save the crores of rupees of the people. And we can make more construction to the people of this country. So my suggestion is about this model act. Actually, I am referring because I'm talking in NHI. I respecting the decision of Supreme Court, High Court, and I have a tremendous respect, regard, and recognition for that. In one of the project, we have taken a decision with the secretary's consent and issue the order to NHI to settle the issue with 325 crores with the party. But NHI officers was not ready to take the risk, and it was not taking decision was the problem there. And because of that, they not accepted the decision given by the ministry. After that, the contractor going to the Supreme Court, and now the Supreme Court has delivered the decision, and we have to pay him 1,300 crores for that. Now the NHI people are asking him for compromise, but he is not ready because the final decision is in his hand. So there is a lot of problem. First of all, before going to the court, most important thing that we need to resolve the issues. Now we have two committees. before arbitration, we have a conciliation committee. And the problem is that in the conciliation committee, there is retired judges are there, some the retired IS officers, retired secretaries, and good officers are there. But they are not taking decision. They are calling the contractors and government officers and they're telling us you make somewhere and making compromise. And that is the conciliation spirit for that. But actually, one of the things which now I'm going to raise this issue into the conciliation committee and arbitrator also, that whenever if there is a decision, you should write the name of the officer who is responsible for delay, and on the reason of that, these all negative things we need to find out and rectify the thing into the system. The problem is that after, because of not taking decision, again the same thing is repeated. So somewhere I will request you that we need to find out the way out, and we have to change the system accordingly after the decision of the Supreme Court, that we how in the future there should not be such type of anything which is going to lose the money, the public money, because of the wrong decision or not taking decision, or because of delays, the government is facing the problem. So now already we are now taking a lot of decision, but I will request to particularly your forum, that time is the most important thing. I have a respect with the courts, but I am also agree that courts are over pressurized because the number of cases are more. But I have a humble suggestion. Can we make this by making use of technology for taking any claims or anything from the contractor in the court in a prescribed form, by which we can decide the issue and we can develop different type of softwares, by which we can also reduce the time period. That is exactly, I will request you that where if you can find out some solution for that. Now the problem is that before arbitration is taking a lot of time. I am giving you the example. When I was Water Resources Minister, there was a dispute between different states. So 17 cases, 17 disputes related with the different states was going on. So I used my office and I called the chief ministers 2 times, 3 times, 4 times. And I said, no, you have to take the decision. In one of the case, after partition, out of 6 rivers, 3 rivers water was getting India and 3 to Pakistan. But the problem is whatever the water which we are getting in the 3 rivers, that goes to Pakistan. There was no dispute. There was no, because no one was bothering about that. But regarding Punjab, Haryana, Himachal, Rajasthan, the problem was there, and I take it and forcefully I resolve at least the 9 disputed between the states. I have tried my level best to resolve the issues between Maharashtra and Gujarat and Karnataka and Tamil Nadu related to the Kaveri. I feel that it is possible. There is no problem. There is no water shortage problem in the country. We have got ample water available. Honorable Justice Nageswara is from Andhra Pradesh and Telangana. He knows the situation. I was constructing that Polavaram dam. And after Polavaram, the water going to the sea is 1300 TMC. And I was decided with the 2 scheme, taking that water from Polavaram, backwater of Godavari, taking to Krishna to Pennar and Pennar to Kaveri, and going up to the tail end of Tamil Nadu. We can resolve the water problem. Water was available. But the problem is that everywhere, many legal issues in the courts and everywhere, where by mutual understanding and considering the interest, public interest, we can take the decision, we can resolve the issues. And after that, in the democracy, we have a highest judicial system for that. But before that, these are the problems we are facing, and particularly in NHI, where we are working every year, 5 lakhs crores of road construction. And I will request you The only one thing which I don't want to make any comments to against anybody, but I will request you that time is the important clause. I respect the lawyers. I remember when I was a young student, there was one case. I was a big landlord, and the case was in the Rent Control Act. The court was there, and 8 years we were fighting for that. And that tenant was defaulter, was not giving rent from 3 years. But for decision of this case, it takes 9 years to resolve the issues. So my suggestion is there is a quite pressure on the system, and the number of judges and other things are not very much adequate. These are the problem where the government and judiciary will find out the solution for that. But in the present system, if there is any chance that we can reduce the time and we can making the decision-making process fast. In Delhi High Court, there was some arrangement related, just like that Lok Adalat, there was some forum where the contractor and other advocates, they're coming together and they find out some solution and try to resolve the issue in the presence of the honorable judge. But somewhere I feel that we can resolve the issues. My own experience in my ministry, we resolve the issues of 3,85,000 crores and save the Indian bankers from the NP of 3 lakh crores. It's possible. We have a transparent, time-bound, result-oriented and corruption-free system. Our intentions are good. And actually the way in which in government, all model agreement in government, they are all supporting to the government. They are not thinking about the banker. They are not thinking about the contractors. All are one-sided. And I will try, in my ministry also, we have taken a lot of decision to improve this. And now this is the time for we are making a lot of investment in infrastructure, in power industry, in the irrigation, in the road construction, in the urban ministry. In particularly, we are making a lot of solar power, and all we are facing with all many of different. We want to make Indian economy or the world #1 economy, to make Indian economy as #1 economy in the world. And for that reason, we need to change a lot of things. I really appreciate the approach of the association, and this is very, very important issue. If you can successfully find out the solution on these issues, I am confident that we can save the crores of rupees of the people, particularly of the society, about the country. I have asked Mr. Ratan Singh, founder and chairman of SCL India, to bring forth the suggestions coming out of this 3-day conference to me also, to my ministry. And I must assure you, all the government of India will work on suggestions made by you. Already the Prime Minister appointed one committee under my chairmanship, the infrastructure committee, which is responsible for find out the solution where we are facing the lot of problem in the projects. And I will request Honorable Justice of the Supreme Court, if it can possible for you, regarding the financial matter, sir, it is very, very important. It should be time bound. At any cost within 3 months or 6 months, the financial matter issues, contractual issues, because their repercussion is very, very high. And many of the companies are destroyed. The people are losing, they are on the road now, sir. Because after they are completely collapsed. And if they're getting thousands of crores, what is the use of that, sir? The companies are collapsed. The people are collapsed. Once upon a time, their share cost was 5,000. It comes to 5 rupees. And all the big companies, because all big companies are working with me, they are facing crucial problem. So this is the time for the system in the government or in the judiciary. The time is the important thing which I feel that. And we have to consider the importance of the time. And we have to reduce this delay time period by using the technology, by using the system, something change in it, it can be possible. Even I will request honorable lawyers also. They are coming to the court, taking the date. Again, it is to be postponed. Somewhere they should have privilege for taking 2 or 3 times the date for it. But if it is going to be a continuous process, that this delay is going to create a lot of complication financially for the government and for the contractors, for the investor and for the bankers. So this is really a very, very important issue touching to my heart, because last 20 years I am working in this system. I'm not the expert of judiciary, but whatever the experience which I am getting in particularly with the system, now I have already decided to call a meeting of arbitrators and conciliators. I am telling them there should be a prescribed form. If contractor, if you want to go for the arbitrator or conciliation, he will apply that. Within 15 days, NHI will take the decision. It will go to conciliation committee, and the committee will give date either by video conferences, by using technology, but they should decide the case within 3 months. So I'm going to tell them, I don't have any reservation about your decision. Whatever you want to take the decision, you can take it, but you take the decision within 3 months. Somewhere this time clause is very important. And this is very important for Indian economy. This is very important for the public money which we are wasting because of the delay. And I'm really giving my special thanks to your committee, and particularly Ratan Singh ji for organizing this seminar. This subject is very touching to my heart, and you giving me the opportunity. And today, really, I will be happy that your solutions, suggestions to me, to the government, 100% we will try to implement that. Once again, I'm giving my all best regards to all of you. And yeah, you giving me the opportunity to express my thoughts on this subject. From last 7 years, I want to tell something from my experience to people like you. You give me the opportunity for that. I'm very much thankful for you. Namaskar. Dhanyawad.
I thank Honorable Minister for taking out the time from his busy schedule to grace us with his presence. It's time that we hear from our keynote speaker, Professor John F. He's a Queen's Counsel Arbitrator at Keating Chambers and Emeritus Professor of Engineering Law at King's College London. I'm sure all of us know Professor F from his textbook on construction law, an essential resource for any construction lawyer or professional. Professor F is originally trained as a civil engineer, becoming a specialist in geotechnics, who practices at the bar, becoming Donald Keating's last pupil. His professional activities have included serving on the court and appointment as Vice President of the London Court of International Arbitration and as the President of Society of Construction Arbitrators. Now, let us hear from Professor F.
Thank you for this opportunity to deliver a keynote address to your conference, and I wish you every success with the event. I would first warmly welcome the decision to establish the Society for Construction Law in India. There can be no doubt that India is one of the world's major consumers of construction. India also has a highly developed legal system, and so bringing these two together is logical and timely. But I first ask the question, what is construction law? And my answer is that first, it is not an exclusive club for lawyers to earn large fees from the misfortunes of construction promoters and practitioners. Lawyers, of course, have their place, but they must operate alongside engineers and architects and surveyors and become one of the team who are seeking to make construction projects work to the benefit of all parties. Construction law is not an exclusive set of rules applying in India alone. It is an international and indeed transnational subject which should draw on and contribute to construction law experiences and construction law cases from many places, including the UK, Australia, the United States, and other common law countries. Construction law is a subject worthy of study at the highest levels. It is well established at master's degree level, typically studied at post-experience level, that is by people who have usually a professional qualification and certainly a minimum amount of experience in the construction industry. But additional to all that, it is studied by both lawyers, barristers and solicitors, and on an equal footing by engineers, architects and surveyors, all with a background experience of construction. Construction lawyers from all these disciplines, from UK and other countries, have in recent years become well established as the leaders of major contractors and consultants and specialist firms, also as expert witnesses and dispute resolvers. And there is no doubt that the career prospects in construction law at all levels and for all disciplines are excellent. As infrastructure plays an increasing role in international development, so it becomes increasingly important to establish internationally recognized institutions and financial bodies to facilitate construction. Most important of these bodies is the World Bank, which finances a large proportion of international infrastructure work, and FIDIC, that is the International Federation of Consulting Engineers, a body currently based in Geneva. FIDIC has recently introduced a raft of new training programs, all based on construction law and aimed at producing a body of internationally recognized practitioners managing major infrastructure projects throughout the world. The reach of FIDIC would be hard to exaggerate. It covers all 5 continents, including India, and has practitioners from all over the world, and its committees are impressively composed of members from every part of the world. So, Construction Law India will need to establish links with all these bodies and will need to ensure that future construction lawyers can have access to high quality training and qualifications here in India. I have no doubt that moves are already afoot to establish links with construction law societies in other countries, especially the UK, Australia, Singapore, and elsewhere. And if I may be allowed to say this, one very positive thing left behind by the British in India is the English language. English is the language of construction projects and disputes. The great majority of commercial contracts around the world are written in the English language, and the great majority of international arbitrations are conducted in the English language. So you are halfway there already, as English is without doubt the language of construction law. No discussion of construction law or infrastructure projects would be complete without taking account of the unavoidable incidence of disputes. Some commentators argue that disputes should be avoided at all costs. I disagree. Construction is an evolving and innovative process, and every advance will not be without risk. Engineers and architects can be over-optimistic. Employers invariably want to improve a design as the work proceeds. All these factors tend to lead to delay and extra cost and, of course, disputes. The key to successful resolution of such disputes is to ensure that efficient and fair procedures for resolution are available, and experienced practitioners are also available to put those procedures into practice. I'm aware that in the last few years India has made great strides in improving its arbitration laws and practices, but it is also said that in India arbitration is still the poor relation of court actions, and that the problem of court intervention in arbitrations continues. These problems will not be solved overnight, but it will be helpful to bear in mind some principles that have been established in the UK and elsewhere. First, the courts are there to support arbitration and not to take its place. It's there to support both arbitration and all other forms of alternative dispute resolution, or ADR. The efficient resolution of construction disputes requires enhanced involvement of construction professionals, both lawyers and other professionals, including engineers and architects. And it must always be remembered that money expended on construction disputes is money no longer available to invest in construction. Now, the UK has a very thriving dispute resolution industry. Some of that is directed to disputes between UK parties conducted within the UK, but much of the activity is applied to international disputes involving non-UK parties, some in London, but much overseas, in Europe, and increasingly in the major international dispute resolution centres such as Dubai and Singapore. This is good news for UK, as it represents a large amount of foreign earnings, whether conducted in London or abroad, and it provides lucrative employment for experts, for arbitrators, mediators, and all construction professionals. And I suggest this should be one of the ambitions of SCL India. Now, I have mentioned training in construction law. In the 1980s, I had the privilege of becoming director of the first Centre of Construction Law in the United Kingdom at King's College London, which was also the first training facility in construction law in the world. My background as a civil engineer, to which I added a legal qualification, led at the outset to my directing the King's Centre such that construction law and dispute resolution was taught to a cross-professional intake of lawyers, engineers, architects and surveyors. And I'm delighted to report that whilst King's was the first centre to establish training courses on this basis, this has been copied in 3 other centres within the United Kingdom and by parallel courses in other countries, including Australia, Singapore and elsewhere. Now, the idea of cross-professional intake to construction law courses was not an original idea of the Centre for Construction Law at King's. It started with the SCL UK, which was established with the same mixed professional catchment some 5 years earlier. At King's College, we turned the idea into a formal academic course, which today remains a world leader. So I recommend all these experiences to the Society for Construction Law in India, and trust that construction law will develop into a healthy, cross-disciplinary subject in which all participants can find their own appropriate place. Thank you for listening.
Thank you, Professor Uff, for your indispensable contribution to the practice of construction law and condensing your decades of experience for us. I'm sure each one of us has much to take from your thoughtful insights. As we come to the end of the first half of the inaugural session, we cannot but thank each and every one, for which I invite Mr. Tejas Karia to render the vote of thanks. Mr. Karia is a partner and head of the arbitration practice group of Shardul Amarchand Mangaldas. Without doubt, he is one of the leading arbitration practitioners and the who's who for arbitration in India. He is also the Vice President of SCL India and has been a pillar of support who has driven this biennial conference from its very inception, along with Mr. Ratan. Mr. Karia, I request you to please kindly address the vote of thanks.
Thank you, Raghav. On behalf of SCL India, it is my honor to express vote of thanks to all our speakers today, the organizing committee, our sponsors, and each and every one of us. To begin with, I would like to thank Honorable Mr. Justice Nageswara for taking out time from his busy schedule and sharing with us his thoughts on the construction industry and the judicial support in dispute resolution. He also expressed the need for skilled arbitrators to resolve the construction disputes and also subject matter experts. And we have seen that in construction arbitrations, if we have the experts who has knowledge about the construction industry, it has always helped us to save time in terms of understanding the issues and coming to the right conclusion. We have also heard Honorable Minister, Mr. Nitin Gadkari, Minister for Road Transport and Highways. He, with his experience, shared the cost of time and how we can reduce the time and cost. He asked all of us to find out the solution for on decision making. I remember last week I was in Hyderabad, where Justice Nageswara Rao was also there at the inaugural session of IAMC. There we actually discussed the role of institutional arbitration in reducing time and cost, and also having an oversight mechanism of all the public sector undertakings and government departments to reduce the time and cost in resolution of dispute. This conference will have deliberations on each and every aspect of this. And as Honorable Minister has said, we will go back with the outcome of the discussion which we have on this conference and see that how best we can resolve the issues on time and cost. I would also like to thank Professor John Uff for his keynote address. His keynote address identified the issues the construction industry is facing world over, and also the issues which the arbitration system is facing in India with the intervention of the court into the entire arbitration process and how we can come out of it. I'm thankful to Professor John Uff for his valuable insights. Mr. Ratan Singh is the president of the SCL India, and we conceptualized this conference in 2017. We have come a long way in last 3 editions. This edition is virtual and not physical, but even we had the 2 conferences were grand conferences, and the content wise this conference is not going to be less than those 2 conferences. Of course, we are not able to meet physically because of the restrictions, but we are going to make it as a great success. I would also like to thank our platinum sponsors for this conference, FTI Consulting, gold sponsors, Kroll, Masin, Madhyam International Council for Conflict Resolution, workshop partners, Secretariat, Driver Threat and Dials, bronze sponsor, Deloitte, DSK Legal, Fireside Chat sponsor, Akin Gum, debate curator, Three Crowns LLP, quiz masters, Atkin Chambers and Barristers, media partners, Global Arbitration Review, latestlaws.com, corridor.law, and all our supporting partners, all the institutions who has tremendously supported SCL conferences from its beginning, including FIDIC, which plays a very important role in the construction arbitrations. Our supporting partner and the event partner, Funkton Junction, has helped us a lot in putting together a beautifully and interactive virtual forum for this conference to make it, even it's virtual, we'll feel as if we are part of the live conference. And last but not the least, the entire organizing committee who has tirelessly worked for putting together the program, inviting the speakers. We have more than 1,200 delegates across the globe. And we are going to have a very exciting 2 days starting from today. With that, we will have an exciting session now. I thank Honorable Mr. Justice A.K. Sikri for sparing his valuable time and joining us today. We will be discussing the construction arbitration on diverse perspective and unified goal. The other speakers are Mr. Ratan K. Singh, Mr. Julian Bailey, Ms. Jane Davis Evans, and Mr. Rajbir Sachdeva. I thank all of you for joining the opening night session, which is going to be a very, very exciting and interesting discussion on this issue of construction law and arbitration. Thank you, everyone.